Bill Purcell, former mayor of Nashville, will tell us about that legislature and whether it's really all that bad or not.
Let me invite the next panel, if I could, just to come up and join us. And we're going to add as well John Geer from Vanderbilt, who was scheduled to be part of this earlier panel and will actually be an ideal addition and final speaker in the final panel of today. As both the last panel and the first panel this afternoon made clear, at the time of the precedents to Baker versus Carr, as well as in the decade that followed, it was a very different time and a very different legislature. To recap, as Macklin Davis made clear, in the 1950s, the legislature was overwhelmingly Democratic. And of course, that is entirely different today. Congratulations, Macklin. As Jerry Flippin made clear, the legislature was overwhelmingly rural in both its membership and also in its focus. As Senator Henry said, perhaps it was more efficient at that time. But if you review the Blue Book of 1960 or think back to that time, it was also all white. And but for one member of the House, Representative Davis of Dayton, Tennessee, they were all white men. In this way, as in some others, the legislature has been transformed in the decades that followed, and I know of no better person than a member of this bar and a member of our Court of Appeals, previously a chancellor in Davidson County, and a man who also served as the law partner of Avon Williams, Judge Richard Dinkins, to talk about the change in this area.
A year or two before Baker versus Carr, and Judge Merritt referred to how the times and the tide was moving. There was a case called Gomillion versus Lightfoot, which was a suit brought by black residents of Tuskegee, Alabama, who had been legislated out of the city limits of Tuskegee. So they were not able to vote in city elections. And a gentleman who was educated here in Nashville named Fred Gray litigated that case to the Supreme Court. And it was interesting when various people have talked about Justice Frankfurter and what have you. Well, Justice Frankfurter had written Cold Grove versus Green. And in Fred's book, he talks about Justice Frankfurter. And the one little thing I want to add here for the younger lawyers, when you're on appeal, arguing an appeal, and a judge asks you a question, answer the question. You never know why the judge is asking, and it's not your role to know why. Just answer. And the reason I say that is in his book, where he talks about Gomillion versus Lightfoot and wanting Frankfurter's vote. The only thing Frankfurter knew about the city of Tuskegee was that there was this university there where the airmen were trained. You've heard about the Tuskegee Airmen. And as Fred Gray began his argument, Frankfurter asked him, he says, "You mean to tell me the Tuskegee Institute is outside of the city limits of the city of Tuskegee?" And I said, "Yes, sir, Mr. Justice Frankfurter, it is. I believe," and this is what Fred says, "I believe that was the determining factor in getting Justice Frankfurter's vote." Okay? So you never know why the judge is asking. You just answer the question. Okay. But I also want to say that 3 years after Baker versus Carr, the Congress passed the Federal Voting Rights Act. And I think it is absolutely clear that the momentum of Gomillion versus Lightfoot, of the Minnesota case, of Baker versus Carr, those were hard cases because those were litigated under the Constitution. And as you know, the constitutional lawyers among you, you have a higher bar, a higher burden of proof in constitutional cases. A lot of the cases that I litigated were under the Voting Rights Act, which was made a lot easier not having to prove a constitutional violation. The last thing I want to say, because I told Macklin I would, the no further proof of how great America is, the constitutional litigation, the voting rights litigation, is that in 1992 or thereabouts, in a federal courtroom over in Memphis, and I think Judge Merritt was on that three-judge panel for a while, Macklin Davis and I were on the same side of the courtroom in a reapportionment case challenging the 1990 reapportionment of the state legislature. As a result of that lawsuit, there is now a minority House district in Jackson and thereabouts.
Which is not a bad segue to explaining perhaps why I'm moderating this session. In 1986, not only had people in Tennessee and other states begun sending people of color to their legislatures and women to their legislatures, primarily from cities in this country, but especially in this state. But occasionally they sent somebody from Philadelphia, and they sent me. I arrived in the Tennessee House. Literally the first person who I saw after being sworn in, who identified himself and gave me advice, was Ward DeWitt, who came over at that time and said, "Congratulations, serve one term and quit." It's what I did. It's the secret of my success, and you should have that success as well. It was very comforting. It was very much appreciated. I did not regretfully follow Ward's advice, but I did stay long enough then to see a majority leader elected from the city for the first time in our history, which occurred in 1990. I watched people from urban districts begin to be involved in leadership within the body itself, which had not occurred previously. And then, as a result of that role, I found myself sponsoring the very bill that Judge Dinkins just mentioned, because I passed the bill that was found to be unconstitutional, and I passed the bill that was then ultimately found to be constitutional, and was therefore responsible for being on all sides of both defeat and success in this redistricting effort. But in that process, I asked the question which any of you would have asked. I don't know anything about this. I said, who knows about this? And what I was told is, Mike Murphy knows all about this. Representative Mike Murphy drew the lines in Davidson County for then Speaker Jim McKinney in the 1970s. He drew the lines in Davidson County and other counties for then Speaker Ned McWhirter. And if you ask him, perhaps he would do that for you as well. Representative Mike Murphy served until 1986 in the Tennessee House, then ran for the Public Service Commission, served together with Steve Cobb, here well known to the members of the Tennessee Bar Association in the room. It's my pleasure to recognize Mike Murphy and ask him to explain what he did, especially in that first set of redistrictings, and especially as they address the issues we've talked about.
Throw in one thing that goes back for just a second. Earlier we were talking about elections and how there were the Tennesseans have a slate, everybody have a slate. You had 6 slots, the top 6 would win. Well, as Baker v. Carr came along, not only did the rural legislators not like giving up their power, but they came forward with the plan of dividing the urban communities into districts, because otherwise they were afraid that the Tennessean and labor and local government officials would get together, and all the Memphis people would look alike, and all the Nashville people would vote alike. And that's one of the reasons that got changed, was it was in reaction to a fear of losing power. And that's where that came from. It wound up, for people of color, a godsend that you had actual districts. But that's how we got from when we're talking about earlier to today and doing legislative districts. Just a quick history. I went to Vanderbilt, graduated. I had a 9-month wait before I went to quartermaster school over in Fort Lee. The comptroller's office was kind enough to find I guess, a patronage position for me in the Office of Local Government. For 9 months, I traveled some of the most rural areas of this state, helping their county court redistrict. I then went to Vietnam, served as a company commander, came back, and was elected to the legislature. Somehow, probably one of my enemies informed Speaker McKinney that I had done that, so he asked me to do the state in Tennessee. You didn't have computers back then. You didn't have, we actually took county highway maps and divided them. In your urban areas, you had the information that you could do pretty well, but in the rural areas, we would count houses in little areas that we had drawn off on the map, and then we'd multiply the number of houses by the average people per household in Tennessee. And that's how we started out in rural areas, trying to do redistricting. The other thing was that this was still a battle to try to get a bill through. And don't forget, a lot of things that happen with redistricting, you've got to have 50 in the House, 17 in the Senate. You've got to have the approval of enough votes to get it passed. So we still had opposition then from people who did not want to split, particularly in the rural areas, split counties. So we came up with an interesting compromise in 1970, 71. We came up with 2 plans. One that split very few counties, or actually we didn't split any counties. When you did that, the closest margin you get would be probably, I think, my memory is maybe 27% from top to bottom. Most of us who had been involved and understood what the court cases had said were working on a second plan. And that was one that we're trying to hold down to about 2% margin of error. And we wound up going to the House floor with Plan A and Plan B. We had maps scattered across the floor of the House. I had one person who was helping me, Terry Dale, who had it was me and Terry and an adding machine and highway maps. And that's how we did in 1971, how we did the House. The funny thing was that, of course, since we didn't have in the rural areas the census data, we had to describe it visually or geographically. The line goes north along an unnamed creek till it comes and hits the southern edge of the cemetery, and then east. And the one good thing about that in the courtroom and on the floor of the House was no one was going to take the time to draw these little circles and everything on maps and try to figure out whether we were right or wrong. Nobody was going to check our math. And and we got to the floor and we managed to do that. I have to tell you, there are a couple of good stories about that. In the Nashville, Knoxville, Chattanooga, and Memphis, we let legislators sort of draw their own area. And I have to tell you the one story that in Chattanooga, we had a minor problem. We had 2 Democrats. We had enough people for 2 Democrats, but unfortunately they were split up by Missionary Ridge. And you had to make the districts geographically contiguous. At one time, one of the Democratic districts was connected through the highway tunnel that went under Missionary Ridge. There were a lot of things like that that went on. Basically, it was a difficult situation. It was not nearly as partisan back then because we didn't have the capability of doing it. We didn't have the computers and the voting files and everything to do that. It's become more partisan now. But generally speaking, trying to get to 50, what you want to do is first, you're going to try to take care of all the incumbents as you can because you've got to get to 50. It is a very, very, people will fight over whether they're Republican or Democrat. They'll fight over their district because those are the people who got them elected. A Democrat wants to keep everybody who voted for him because they must be the smartest people in the world. A Republican wants to keep all the Republicans who voted for him because they've got to be the smartest people in the world because they voted for him. So just with that, that's sort of a beginning of what we started out doing, moved to computers as the years went on. A lot of changes were made. Computers have made it a lot easier. Bill?
Slightly more than halfway through the 50 years that we're reflecting on in this brief time this afternoon, a lawyer, member of the Nashville Bar Association, apparently said aloud that he thought, perhaps, that he should be in the state Senate. And when it came time for him to actually think about being in the state Senate, he was no longer in the district which he had thought was the place in which he would run. That young man, member of our bar, well known, I think, to everyone in this room, just literally this week, well, in fact, it's more than that, it's 2 days ago now, left public life after those many years of distinguished service in our state Senate, and it's my privilege to present now just a member of the Nashville Bar Association, a longtime state senator, Joe Haynes.
Thank you, Bill. Well, you know, it takes 3 people to talk you into running and 3,000 to talk you out of it. Those 3 people apparently came to see me in 1984, but I made some mistakes because I announced pretty early that I was going to run. I was running against an incumbent Democrat who he and I had grown apart over some issues, and the next thing I know, I had forgotten or not paid attention to the fact that the court had ordered the Senate to redraw the Senate lines in Davidson County because they'd taken Senator Henry's district and put Cheatham County in it. They'd taken Senator Crockett's district, which was soon to be my district, and put Robertson County in it. Well, the court held that you can't dilute the rural areas that way. So if one district had to go outside of Davidson County, it had to take in both rural counties. So that was inevitable, that was going to take place. But this is where the mischief occurred. Senator Crockett decided that he didn't want me to run against him because I had a wife who had just been elected 2 years before to the General Sessions judgeship, and he thought that I might attract more votes than he'd want me to attract. So he put me in Senator Henry's district, and I live in Goodlettsville. And that's pretty difficult since Senator Henry's district was in West Nashville. Now, Ron Ramsey's done that again to my district, but that's okay. But Macklin, I guess you played a role in that. But anyway, back then, he did it by running the lines down the interstate, and it was a little finger, and it ran it around our house in Goodlettsville, and suddenly I was not in my district that I could run because Senator Henry couldn't run for 2 more years. And I certainly didn't want to run against Doug Henry, who was a friend of mine. So Barbara and I decided we'd move back into the district before they confirmed this, and we did. We moved out of our house into an apartment back in the district before they could get through drawing the lines. Well, the next issue was to make sure you got on the ballot. And we managed to politic our way on the ballot in Davidson County through the Election Commission. Robertson County was a breeze after Davidson County put me on the ballot, and then Cheatham County soon followed. Well, Next thing I know, that Bill Leach, who's the Attorney General, assigned now Judge Joe Haynes to the case, and they filed suit against me to take me off the ballot. That was tried in front of Chancellor Brandt, and we were successful in staying on the ballot. So that was the first hurdle. And I was in the district because we had moved. By that time, I didn't have any name recognition in the district, in the other counties. But if I went somewhere like in Cheatham County and Ashland City, they'd say, "Oh, you're that fellow that they drew out of the district." They didn't even know my name, but they knew I was drawn out of the district. So that's the mischief that comes with reapportionment. And as soon as I was elected, I redrew the lines, put my house back in the district, and moved back home. Additionally, reapportionment is a strange bedfellow in many ways. In 1992, I didn't have any say-so over how my district was drawn, and I'd been in the legislature by that time 8 years, soon to be 8 years, and Bob Rochelle controlled it. And he took me out of he took me out of Cheatham and Robertson and put me in Davidson entirely, and I didn't want that because I'd made a lot of friends in those two rural counties, and I felt I was pretty strong. But the next thing you know, I'm running in a new district. They put me in John Hicks's district, sort of forced his retirement in Donaldson Hermitage, and it attracted me opposition. But I was successful in winning. But then fast forward 10 years, by that time I'd worked my way into the leadership, and I drew Bob Rochelle's district that time, which he didn't like. And I had sent Ben Ashley to tell him that he wasn't going to be successful in trying to beat it on the floor, and Bob backed off. But it's amazing what bedfellows reapportionment makes. This last time, I didn't have anything to do with it, and Ron Ramsey and I couldn't agree on my district, and he was successful in putting me in Bellevue from Goodlettsville, and that now it's a Republican seat.
And now I'm in Senator Henry's district over in East Nashville, and he has actually left early because he's making his way to his new expanded district around the airport, Percy Priest, and portions of northern Alabama. The last member of this panel will, I hope, be able to bring some perspective from political science. John Geer is an outstanding member of the faculty at Vanderbilt. He's the Gertrude Conaway Professor of Political Science there, has led the department, has been a leader in his field, is the producer of the Vanderbilt poll, which now over the last 2 years has been the single best poll on political and other attitudes in the state of Tennessee, and is also the father of a second-year law student at the University of Tennessee, which for most of the people in this room will be the most important thing I'm going to tell you about John Geer. Unless you're thinking about a PhD in political science, you need to look for his daughter when she returns from Knoxville in the years ahead. John Geer.
Thank you, Bill. I suspect, yes, there's no doubt that my daughter is by far my great joy of my life. It's great fun to be here and to try to provide, don't worry too much about political science perspective in the sense it's not going to be filled with numbers and boring statistics, but I do think that given the kinds of comments that have been made so far, Baker versus Carr was about equality, about one person, one vote, and behind that was some notion, not more than some, but a belief that we had to have competition, that by making things equal, we generate competition, and that with competition, we get better outcomes. But that's an assumption, and that's certainly what we want to have, but if you think about the 2012 election and some of the stories that we've just heard, there certainly isn't as much competition as there should be. I mean, in the House of Representatives, for example, 95% approximately of the incumbents were reelected, and without much difficulty. If you take a look here in our own state legislature in those various districts, huge numbers went without competition. And that's a serious problem. And in fact, one of the things that's often laid at the feet of this lack of competition is the rise of polarization. That this country is polarized, this state has its own kinds of polarization, and a lot of people are worried about it. If you think just about the reactions to the outcome of the 2012 election on just Tuesday night, it was again an example of polarization. I went back and forth watching Fox and MSNBC because I knew very early, based on body language, that Obama was going to win because the Fox people were not happy. They'd had the exit polls. They weren't talking about them, but they were just fidgeting a little bit. And Chris Matthews was not having a nutty. That told me that probably the Democrats are doing pretty well. But we have this kind of polarization. It turns out at every state, at every corner, we have polarized news media, we have a polarized country, we obviously have a polarized Congress. We have lots of problems on that front. And a lot of people will lay the blame on gerrymandering, on the fact that reapportionment is done in a way that is not generating competition. And that's certainly at one level true. But there's two things that political science has done that gives us pause, and one's an obvious one. That is that in the House of Representatives, there's been a steep increase in polarization. No debate about that. However, that same level of increase is unfolded in the US Senate, and there is no reapportionment in the US Senate. So that raises, okay, maybe the story is a little bit more complicated. Moreover, political scientists have tried to redraw the map in the House of Representatives to see if they could in fact make it more competitive. So they've actually run simulations, say, okay, forget about the politics, forget about whether you're going to maximize Democrats or Republicans, just try to redraw the districts in some sort of fair way and come up with a lot of standards. In every single case, they continue to produce non-competitive districts. So even when they're not intending to produce them, they seem to be being produced. That gives us more pause. And I think what's going on, at least part of the story, is changes in this country that oftentimes there's a very reasonably well-known book called The Big Sort, where it turns out that Democrats and Republicans are just living in different areas. So if a student of mine is graduating, and let's say she's got 2 job offers, and she has a job offer in Dallas and she has a job offer in San Francisco, and she takes the offer in San Francisco, I know she's a Democrat, and if she takes the offer in Dallas, she's probably a Republican. Why? Because people are sorting themselves along this line, and this is a concern. And it's such a concern that it's preventing us from doing the kinds of goals, meeting the kinds of goals that were spoken about, aspired to in cases like Baker versus Carr. And so there needs to be, and political science has some things to say about this, there needs to be new ways to think about districts. So for example, imagine relaxing the assumption that a district has to be contiguous. The reason for contiguous districts was because 200 years ago, travel was difficult, communication was difficult. You had to make them contiguous. Now, that map that was up there with the bizarre kind of gerrymandering picture we've all seen, that's barely contiguous, but imagine if you relax that assumption. Jim Cooper could represent both Knoxville and Nashville today under the kinds of information we have and the ability to travel. He could do that. I'm not advocating it, but I'm advocating that this is not a simple story, that gerrymandering is part of it, but it's not quite as simple as that, and there's other things that are unfolding. And so we do need to worry about this polarization. We're facing a fiscal cliff. We're facing issues in our own state legislature that need to be dealt with. And reinfusing real competition between both parties would be good for the process, but right now we're not there. But it can't be all just gerrymandering. So on that note.
Well, I think at this point, it probably is best for me to give you one more fact and then move to the last portion of this program this afternoon. And that one last fact is that on March the 16th of this year, Bob Tuke and 2 other lawyers, but Bob Tuke is the member of our Bar Association, filed suit in the Chancery Court of Davidson County, saying that the apportionment of the State Senate of Tennessee was inappropriate and should be set aside. And there'll be a hearing in the Chancery Court on December the 14th of 2012. And so the next 50 years begins. Please thank the panel with me.
Before I call Scott Neely up to provide the last moment of interesting information, which will basically give you an idea of where all these people are now. You know where some of them are, they're here. But they had interesting lives after Baker versus Carr 50 years ago. Rody, I'm going to ask you to play hooker number 5, please, sir.
When I look back on it and think of the magic of it, the moment, the mark it left on America, I realized how blessed that I was by quirk of fate to have been a part of that, to have been in it in such a interesting way. And now that I think back on it, I realized, that was really something. But then I didn't even take any notes.
Yeah.
I must have needed a guardian. You would think that I'd taken elaborate notes of all this, but I never did. It never seemed to me to be. They tried my best, taught me into coming to work for the administration. I told them, look, Bobby, I'm not doing that. I don't want to be just another hired hand. I want to be I want to have the right to speak to you as an equal. And I can do it better on the telephone than I can up here being your employee. You order me around, tell me what to do. I'm going to finish this half a thing, then I'm going home.
I'm going to again thank all of our sponsors. I want to mention them by name: the United States District Court Library and Miscellaneous Fund for enabling us to make this a free CLE, the Metro Legal Department and the Nashville Public Library for providing the space and the facilities for this program, Napier-Luby Bar Association, Baker Donaldson, Bass, Berry and Sims, Bone, McAllister, Norton, Bradley, Arant, Bolt Cummings, Gullett, Sanford, Robinson, Martin, Leitner, Williams, Dooley, Napolitan, NBA past presidents, Sherrard and Rowe, Tune, Entrican and White, Waddy and Patterson and Waller. I think I should have just named the ones who were not sponsors and it would have gone quicker. But we want to thank them again for their generous support, and without them this would not have been possible. Scott, come and regale us with what happened after Baker versus Carr.
Thanks, Ed. As a very small fish in a very large and deep pool of panelists, I'll try to run through these as quickly as possible. Some of the major players in the Baker case, what happened to them after it was all over. But first, starting with Chancellor Steele, the Nashville judge who got the answer right the first time. He wasn't on the bench much longer, a couple more years. He went on to practice at Gullett, Steele, and Sanford. And as Judge Cantrell mentioned, he was regarded as one of the more able trial lawyers in town. Mr. Baker in Memphis, Shelby County. David, thanks for showing up. Thank you, sir. That's a surprise. He remained as the Shelby County executive until the mid-'70s. He passed away in 1999 at age 85. And turning to Tommy Osborne, Mr. Hooker spoke of him so eloquently, I don't think I could add much more, but that there are many heroes in this story, and none bigger than Mr. Osborne. I think he has a daughter that teaches at Harpeth Hall. Is she still there? Mayor West, who provided the funding for this whole thing. He ran for mayor in '63, but lost to Beverly Briley under the new Metro Charter. He too went on to practice in the private sector and passed away in 1974. JFK and RFK, much has been said about them, but Bobby Kennedy did say at one point that Baker was a landmark in the development of representative government. Archibald Cox went back to teaching constitutional law at Harvard in 1965, and side note, he was later appointed as a special prosecutor in the Watergate investigation, and in 1975, President Nixon wanted him fired because of his requesting certain documents. Then AG Elliot Richardson refused to fire him and resigned. The next in line refused to fire him. I don't know if he resigned, but then the next in line, Robert Bork, did fire him. And so perhaps that left some resentment in the Senate when it came time for his Supreme Court nomination. Bork, by the way, did agree with the Baker decision, and Archibald Cox died in 2004. And lastly, I believe it was edited out at this evening's program, but at one point during the Nashville contingent's trip, one of their trips to D.C., they were directed to the office of Byron Whizzer White, who was assistant AG in the Department of Justice during the Baker years. And he was perhaps the first person to bring up the issue of how this whole case might affect the African-American community. And so I thought that was fairly prescient of him. He was apparently an incredibly bright guy. President Kennedy appointed him to the Supreme Court the same year Baker was decided at age 44. And by the way, he had already served in World War II and had played 3 years in the NFL. So that's my portion. Ed, I'll turn it back over to you.
You know, Baker versus Carr was something of a miracle when you look at how all these moving parts came together and enabled that case to be heard twice by the Supreme Court and ultimately decided in the way that it was. And we have just witnessed a second miracle. This CLE program has finished precisely on time. Before you leave, do not forget to get your forms outside, fill them out accurately, sign them, and turn them in so you will get your free 3-hour and 25/100ths credit. Thank you for being with us. Thank you very much.
The 14th Amendment itself suggests to the contrary. It says that no state shall deny to its citizens equal protection of the law, and it specifically prohibits an abridgment of the right to vote for members of the legislature.
Do you agree with the Solicitor General, or don't you, that there may be inequalities as between urban and rural voters that do not conflict with the 14th Amendment?
I do not agree that.
Then you don't have...
I agree that there may be inequality.
Well, Mr. Osborne,
Yes.
There's more here, as I understand it, than inequality between urban and rural voters.
Well, of course, much more.
Apparently inequalities among rural counties, between rural counties, of the same size and different size.
It was a club that was organized in 1901, and that is all it amounted to.
But my question was to accept that you succeed in having this statute declared unconstitutional. My question was to foresee the next step. Couldn't your legislature, with entire conscientiousness, then pass an important reapportionment statute, which from your point of view would raise the same question which has now brought you here?
No, they could not. With good conscience and
Not
accept
with your
upon a rational
conscience, not
basis.
with your conscience, but their conscience.
No, both of us are supposed to have the conscience provided for in the 14th Amendment to the United States Constitution.
Then there never would be difference of opinion on this court if you were right.
Can you imagine any case where we hold a law unconstitutional, where there's decided sentiment against what we hold in the community, where the legislature wouldn't try to pass another and trim it as much as possible?
Always they have done that.
Has that heretofore been held a reason why we shouldn't hold them unconstitutional if they are?
Never has this court failed to have the courage to do what it
I would
thought
like
was
to
right.
get your view on one thing, though.
Yes.
Your adversary says that the legislature couldn't meet. He said it was illegal, it couldn't meet, and that you couldn't elect a new legislature because the only apportionment law you have is the one you have. What do you say to that?
Well,
how could you get a constitutional legislature under his argument?
may I answer and not take too long, because I appreciate the time the court has given. In the first place, the de facto doctrine is not as described by the Supreme Court of Tennessee, and the special ruling was handed down by the Supreme Court of Tennessee in Kidd versus McCandless on the de facto doctrine, in which they departed from their earlier pronouncements. But in good legal logic, you actually never reach the de facto doctrine, because the Constitution of the United States, the Constitution of every state in the Union, gives exclusive jurisdiction of the right of a person to sit in a legislature, the right of the individual person now to sit in that legislature, to the legislative body itself. That is...
Suppose the legislative body is unconstitutional.
Well, we're seeking now to distinguish between two different things. We're saying an act of apportionment is unconstitutional, not that the legislature is unconstitutional. The legislature exists independently of any of its own acts. It is the creature of the Constitution. And the fact that the legislature passed an unlawful act of apportionment could not destroy it. It has no power to destroy itself. And none of its acts would by any court of any of the states be construed in such fashion as to destroy the legislature.
You mean you're invoking the de facto idea?
I'm invoking really a more basic doctrine than that. Let's take the Tennessee legislature. It consists of 20 people from the urban areas, the House. The balance of the 99 members come from what we'll call the non-urban communities. The Supreme Court of Tennessee would never examine an act on the question of its constitutionality to see whether people who came from too small a district voted for or against that act. I'm saying that their acts are not subject to attack on that basis.
Mr. Osborne, suppose this, that the Apportionment Act itself were declared unconstitutional.
Yes, sir.
Suppose my reading of Kidd McCandless, as I read it, as I suggested to your adversaries, all it has said is the current legislature would not be validly constituted. Not that any of the actions of earlier legislatures would be invalidated by such.
They did not.
And suppose it's that limited, but then your Tennessee Supreme Court would say, well, the action of the federal courts in invalidating the Apportionment Act does have the effect of invalidating the current legislature. Would that be a matter of state law, or would that be something which we could review?
Your Honors would review that.
Why? How?
Well, Your Honor would always review the question and the extent of the effect of a ruling by this honorable court. One of the things that this court has to do is interpret its opinion.
I have no doubt about that. But suppose the Tennessee court doesn't say we construe the decree of the federal court, but we construe Tennessee law to mean that if the apportionment has been illegal since 1901, or consequently, there never has been a valid legislature, would that be a federal question? As the case that was put to you by my brother Brennan specifically inserted that the state court would be construing the federal decree. And I agree with you, if that were so, then we would really
Then you would review it.
But suppose they don't make any reference to the federal decree and say Tennessee law is such.
Well,
that's a different problem, isn't it? That's all you have to say.
That's a hard question. And
you want me to put you easy ones?
No, but it comes down to this. At first, it would suppose that Tennessee's Supreme Court would say, well, since they weren't properly apportioned, there's been no legislature. And everything is invalid, and there's no way to establish a new legislature. Well, it would depart from every precedent, and yet if they did that, we would be in as bad a fix as we are with a legislature that refuses to apportion. We might be in as bad a fix without a legislature as we are with the ones we have. I'll say that.
Isn't that what they, Mr. Osborne?
Yes, sir.
Is not that what they did say in Kidd against McCandless? The Supreme Court?
Just to be frank, they did. That's what they undertook to say. They said chaos would result. It will destroy the state government.
All right. Now, if that's a matter of state law,
Yes.
they don't take it back. Where do we go from there?
Well, it might have been quite possible, and I'm sure that it was done in all of the cases that have come before this court involving individual human rights. The motto of the Supreme Court of Tennessee is Fiat Justitia Ruat Caelum. Let justice be done if the skies should fall. And yet that same Supreme Court, with that same motto, wrote the decision in Kidd versus McCandless. And I am certain that when the states held that it was all right to exclude Negroes from primaries, some judge wrote that that was perfectly all right and would destroy the state if it were not to the contrary. And so those arguments would have to be met one at a time. We cannot vouch for the wisdom nor for the judicial integrity or the legislative integrity of everyone, but we do say the presumption is that others will follow the law. The presumption is that upon a declaration of the invalidity of this unconstitutional act, the legislature would follow the law. We have no other place to go. We are at the capital of the world.
Well, what you're telling us then is if the 1901 Act is invalidated, we ought to count on the existing Tennessee legislature, then enacting an Apportionment Act which does comply with the law. Is that it?
That's what we should do.
Then I take it you're saying to us, if someone's going to challenge that on the ground that the legislature itself is an invalid body, let's wait till that happens.
Well, the Supreme Court of Tennessee has twice held that it would not entertain such a challenge. Every state in the Union that has had the question before it has held that they would not entertain such a challenge. So I say that we have very strong precedent for never reaching the de facto doctrine for the refusal of the courts. Thank you, guys.
We'll recess now.